We are continuing from where we stopped yesterday. And as you know, today is day 27th of our 12 weeks legislative drafting training. And we are already on week 6 of the training. And our topic is principal provisions, which is the second part of the structure of a bill. We have dealt with the preliminary provisions. Principal provisions are subdivided into two. We have the substantive provisions and we have the administrative provisions. Substantive provisions introduce rights, powers, privileges, and immunities of persons who are to benefit or be regulated by that act. The provisions are drafted as prescriptions or prohibitions or regulations or a combination of one or two or all. Then we have the administrative provisions. The administrative provisions establish statutory corporations and are introduced with care. We dealt with what statutory corporations are yesterday, and what are these administrative provisions? They deal with powers and functions of, the administrative provisions deal with powers and functions, and they can only be those awarded to them by the statute. So if the statute does not prescribe a specific function or confer a specific power to a body or an individual, that body or individual cannot exercise such power. They cannot assume such power. They cannot also exercise or play the function or role that were not expressly assigned to them by the legislation or the act, as the case may be. Number two, it also deals with, that's the power composition of the board. Number two, it deals with delineation. We also discussed what delineation is, the limits, the extent to which a power can be used or exercised, the boundaries of one's power or function or authority. So delineation of the powers and composition of the governing board of the statutory corporation, and mode of appointment and termination of appointments, bearing in mind, of course, the federal character principle of Nigeria. Then delineation of powers, qualification of the chief executive officer, that's the CEO, and other principal staff, mode of appointment and termination, then procedure for meetings of the governing board, functions of the supervising minister, then financial meetings of the governing board, financial provisions relating to the said statutory corporation, such as submission of annual financial reports, then to the legislature, as well as any transitional regime. We also discussed what transitional regime is yesterday. Now, the sample document we are using, or the precedent or case study act that we are using, is the Nigerian Communications Commission Act 2003. Because that act, from sections 3 to 30 of the act, is our area of focus for this particular substantive provision. But the entirety of the act covers principal, preliminary, principal, miscellaneous, and final provisions, well crafted. That is why we are using it as a case study. And we have also enjoined everyone to know that you understand what we are talking about. We also have an assignment which was posted yesterday That is the widowhood leave bill. The drafter of that bill did not do a good work. So, given what you have learned so far as a legislative drafting practitioner, yes, you are, even though you are still in training, given what you have learned so far, the assignment is for you to redraft that bill, put in the principal provisions that were omitted, the preliminary provisions that were omitted by the drafter of that bill. So that is your assignment. This afternoon, we have in our midst Professor Tony Clinton Jaja, our able Executive Secretary of ALDRAP, who will continue with the class from where we stopped yesterday. Prof, welcome once again. Thank you, sir.
No, Ebenezer, you carry on. Today and throughout this week, we are going through principal provision, member things. Those of us who were not brilliant, my father is a lawyer and he told me how to study. So when you're not so brilliant, by the time you're repeating something over and over again, it sticks in your head. Scientifically, doctors say there's something called synapse in the brain. Synapse. The only way I can describe it is if you go to a gas path, the grass there will no longer be green. That is the way the brain is. When information passes once on the brain, it may not, but when it passes repeatedly, it creates a synapse. That thing is called synapse. Just as on a grass, that path where people are always passing is no longer green. So information becomes embedded with repetition, just as people are passing. So that was a technique. My father told me after every lecture, read what your lecturer has just given you. Read it. Then what I used to do in university was I created a study group. For free, I was teaching my colleagues on weekends, whenever we're free. Because the more I was repeating those information from lectures, the more it became a path, synapse in my brain. So that's how we managed to pass, because we were not very brilliant people. So we have to keep reading over and over again so that that thing becomes part of you. Because in our law class, we had 300 students. Then law used to be part-time. So you had all these rich people coming to study law. So we had 300 people in class, and law school was giving us only 100 law school forms. So if your name was not on the first 10 in the class, you would not get law school form, except your father was a commissioner, a minister. So we had to take reading, repetition seriously, so that these things become part of your brain. So now we are dealing with principal provisions. We are going over and over it again so that it becomes part of you. If they wake you up in the middle of the night, this morning before I came to the office, a director of legislative drafting in one of the ministries of justice in Nigeria, his commissioner wanted a bill on they just wanted it. He had drafted it. He wanted me to just go over it before he submits to his commissioner. I'm telling you, a senior lawyer, over 20 years as director of legislative drafting. But immediately I picked up the bill, I started spotting the loopholes. For example, he did not have the arrangement of sections. He puts final provisions before miscellaneous provisions. So immediately I saw that, I spotted what's it called? Principal provisions, administrative provisions. You create something, you do not define it. They created a medical panel. Now, what is the composition of that panel? There must be a chairman, there must be a secretary. You have to define it. You don't just say it will be panel. Who are the members of the medical panels? You have to provide a definition. Now, another issue was the definition of medical practitioner. It's not only medical doctors that are medical practitioners, pharmacists. So in the definition section, you have to provide this. So within less than 10 minutes, just looking at that bill, I knew I gave him the parts of the bills that was problematic. So that's the kind of expertise you gain by going over these things over and over again. It becomes part of you. You can, anytime a bill is given to you, you know what is wrong. Knowledge will take you far. Knowledge is for you to pass exam, but know-how will take you further. There's a difference between knowledge and know-how.
Oh,
Know-how is technical knowledge, competence. Knowledge is what you get. Oh, I want to pass my exams. You cram, you pass the exams. But know-how is technical knowledge, how to do things, practical. So it's not just that head knowledge you use, you write your exams, you pass. In real life, when you meet a bill in real life, how do you know that this bill would be effective? Effective means it would achieve the objectives of the lawmaker. So as a drafter, you know the devices, you know the components of every bill, preliminary provisions, principal provisions, miscellaneous provision, final provisions. And you know the order, the arrangement, how it should be arranged. So when somebody puts principal provisions at the last, you know that this is wrong. So this is what we're trying to do. The more we go over this thing, it may sound like repetition, but the more you go over it, the more you become skilled at what you're doing. And you can, that's when they say they wake you up in the middle of the night, give you a bill. You know what is wrong with this bill. You know that there are certain missing components because you know it. And that's the difference between the ordinary lawyer and a legislative drafting lawyer that has undergone training in legislative drafting. And that's the difference between a mechanic and an automobile engineer. Both of them can repair a car, but the automobile engineer knows the science behind the components of how legislation should be. So we'll go over it again, even on Wednesday, tomorrow, Thursday, and Friday, we'll go over it again. So Ebenezer, you can carry on.
thank you, Prof. Thank you, sir. Okay, we all have, there's an approach I want to adopt. We all have the Nigerian Communications Commissions Act 2003. Can you open that document and go to the table of contents, the arrangement of sessions, so that we see practically, we have stated what the administrative provision is. Now, what are the substantive provisions? Note, we are dealing with principal provisions. Principal provisions is divided into two or subdivided into two. Get this. We have part A of principal provisions, substantive provision. What does substantive provision do? Substantive provision introduces rights. Substantive provision introduces powers. So if you are saying the minister shall have power to appoint, that is a substantive provision. If you are saying the executive secretary or the executive secretary shall have power to appoint, that is a substantive provision. If you are saying the board, the governing board shall have power to appoint, that is substantive provision. What else does substantive provision introduce to the bill? Privileges, immunities of persons. So if you are saying that the executive secretary shall be entitled to maybe a free accommodation, maybe all expense paid holiday trip, maybe medical care for him and his spouse or her spouse, and 4 members of his or her family. That is substantive provision, because that is a privilege that is not enjoyed by other members of staff of that organization. If you are talking about immunities of persons, what readily comes to mind is section 308 of our Constitution. That is a substantive provision. So you see how easy it is to identify these things. Now, how do you draft it? They can come by way of prohibition. So they can also come by way of prescription. They can come by way of regulation. Or you can combine 2 or 3 of these. Then we look at administrative provision. They introduce powers and functions. Now, we discussed what statutory corporations are yesterday. 2, apart from the powers and functions, or let me stay with powers and functions for a while, who is to play what role? Who has what power? Now, constitution of the body to start with. If we are saying, which example should I use now? NNPC. If we are saying, okay, or let me use National Human Rights Commission or Public Complaints Commission. Now, these are statutory corporations. There is a number of persons that should be at the board. If they say 12 persons, do you just pick 12 persons from one family to become board members? The answer is no. They may say one person from each geopolitical zone. Nigeria has 6 geopolitical zones, so you have already taken care of 6 persons. Where do we get the other 6 from? They may look at other agencies of government that have close relationship or whose expertise will be needed for the smooth running of this particular corporation. Then they might also want to have other disciplines whose expertise are needed to be part of this corporation. They might say that Nigerian Bar Association, somebody should come from Nigerian Bar Association. Then you now have the NBA posting somebody as a board member there. They might say somebody should come from the human rights community. Then you have maybe not Horiwa per se, but any agents, the human rights advocates community. Then we have somebody from that community being a member of the board. They might say they want somebody from the military. The military will send somebody as a member of the board. If they say they need a medical doctor, if you check the Mental Health Act, one of the requirements there is that somebody that has minimum of 10 years experience as a medical lawyer in the field of medical law should be a member of the committee. So the person should not just be a lawyer, the person should be medical lawyer. The person should not just be a lawyer of 3, 4, 5 years, minimum of 10 years experience. Now, you see how specific the drafting is. Why? So that issue of ambiguity will not arise. If you are a medical lawyer of 2 years, you already know you are not qualified. If you are a senior advocate of Nigeria and you are not a medical lawyer, if you have PhD in law and you are not a medical lawyer, you already know you are not qualified. So even if through, as Prof we call it, imamadu, man no man, and they put you there, if your appointment is challenged in court based on the fact that you do not qualify, you do not meet this criteria that is expressly spelled out in the act, your appointment will be nullified. So the question now becomes, what if there is nobody to suit that position? Two things are involved. Either the act is amended to accommodate, or the criteria is reduced to accommodate what is available, or that space becomes vacant pending when they get somebody who will fulfill it. But you cannot say because we cannot find somebody, okay, let us now reduce the criteria so that it does not work. So if you are drafting administrative provisions, you will have to be very, very careful in your choice of words. One, you have to be very, very direct and avoid ambiguity when you are putting your qualifications. So if you need a nurse to be a member of the board, what category of nurse should be there? If you need a lawyer to be member of the board, what category of lawyer? If you need a journalist to be a member of the board, what category of journalist? Either by way of academic qualification, or by way of job experience, or by way of sub-specialization. So if you want to talk sub-specialization, you might say you need a nephrologist. If you are setting up a commission for kidney-related issues, and you say a medical doctor, that you are just causing confusion. You can say a consultant nephrologist. This is somebody who has been handling kidney-related issues till he became a consultant in that field. So you are having sub-specialization at a consultancy level. This is the qualification of the person who will occupy this office. Now, federal statutory corporations do not joke with federal character. So you must bear that in mind because it is a constitutional provision. So to have equitable representation of people from different parts of Nigeria, you must bring in federal character. So if you omit it, it will cause confusion. You have to go back to what we dealt with when we were talking about research authority. What does the Constitution say on this subject matter? So because it is a constitutional matter, you must bring in federal character. Then we look at delineation of the powers and composition of the governing board. We have done the composition, delineation of powers now. Who has what power? What roles are you assigning to the executive secretary? What roles are you assigning to the governing board? So that there will not be clash where the executive secretary does something and the governing board overrules him to say, no, 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 you have no such power. And they go back to the Establishment Act, they cannot see where such power was conferred either on the executive secretary or on the governing board. So you should remember that the executive secretary is answerable to the board. So you do not turn it and make the board answerable to the executive secretary. You must define each person's power, the extent to which that power can be exercised. Then, power to appoint. Who appoints? What is the mode of appointment or recruitment? What about termination of appointments? What about giving the person notices, 3 months notice? Can the person just resign and walk away? If you pay the person his today is day 18th February, the person walks into your office, drops resignation letter and walks away. You should provide for that. Termination, if even a person commits an infraction, how do you go about the disciplinary measure? Prof cited the example of the incident that happened in Unizik, the lady that fought her lecturer. Yes, she has been terminated, she has been rusticated from the school, but was the right procedure followed? Does the acting vice chancellor have the power to rusticate? If what other things could have been done?
Ebenezer, rusticates is not everybody that knows the word.
Okay, she has been expelled from the school, meaning she's no longer a student and will not be a student of that institution again. She was not suspended, because the argument on Facebook is that they could have suspended her maybe one academic session and then she comes back. Personally, my personal opinion, when I read the news, I went into theories of punishments. Okay, what theories did these people apply? Why did they punish this girl like this? I concluded that they applied deterrence theory, so that tomorrow no other person will wake up to fight their lecturer either in Unizik, or Uni Abuja, or University of Lagos, or Unijos. So if you recall that the person who tried this in Unizik was expelled from the school, you will know that if you try it, that will likely be your punishment. So they don't want lecturers facing harassment of any kind by students. and get away with it. That was my conclusion. I am in support of the decision of the school. However, was the procedure right? The decision, because we are talking about powers here. The acting VC that suspended, does he have the power to suspend? That is now the question. So if that decision is challenged in courts, which may not likely be, but if it is challenged in courts, that the court will nullify that decision. Not because the decision in itself is wrong, but because the person used a power that was not conferred on him in his capacity as an acting vice chancellor. Then we look at we've talked the qualification of the chief executive officer. We've talked about the delineation of power too. As the chief executive, the CEO, what will be the qualification for the person to be appointed as executive secretary of National Human Rights Commission? What qualification should the person have? For a person to be appointed as executive secretary of Public Complaints Commission, what qualifications should this person have? Now, I am not discounting the issue of lobbying. I'm not, okay, something happened, University of Abuja, now Gowon's University. The vice chancellor there, last December, they did one appointment and a lady was announced the vice chancellor. And some lecturers protested. They wrote a petition to the president, wrote a petition to the Minister of Education, wrote a petition here and there. Just early this month, that lady who was appointed in December or early January has been removed from office. That the procedure was wrong, that she was not qualified. The same thing happened in Federal Medical College, Otukpo. That should be around November. Yes, November 2. Somebody was appointed and they removed the person to say the person's procedure of appointment was wrong. The person was not qualified. This UNICEF we just talked about, one Professor Ben Odo was appointed the vice chancellor, and this same thing happened. All I'm talking about in the course of the last 4 months, these 3 universities, we are talking about qualification. So what should make this person qualified? Because those people, they use, okay, my brother is a senator, my sister is this, my uncle is this, I know the PA to the president, I know the SA to this person, and they got appointed. But when you go back to the qualification of the person who should occupy that post, qualification is 1. 2, procedure is another. For the VC of Abuja, I read that she was not qualified by the initial publication advertisements for that office. Then when she entered that office, she caused another advertisement to be done, which now suits her qualification. So the second advertisement will be, okay, since with this I am qualified to be. But when the books were opened, when the procedure through which she emerged was checked, it was not in accordance with the establishment procedure, with the established procedure. Then we look at procedure for meeting of the governing board. How do you convene a meeting? How regularly should the governing board meet? Should they meet once in a quarter? Should they meet once in a month? Should they meet once in 6 months? Should they meet once a year? That should be spelled out. 1, venue of meeting. 2, mode of convening a meeting. 3, who should send out the circular for meeting. In the absence of the person, who else should send out circular for meeting? How many days prior to the meeting should the notice of meeting be sent out? All this should be spelled out. Can they have a virtual meeting? How many people will constitute the quorum? Assuming there are 15 members of the governing board, what number constitutes a quorum that can make a binding decision on the governing board? That if they take a decision or pass a resolution on a subject matter, it will be that the board has passed a resolution. Those are the things you address here. You spell them out. Then, functions of the supervising minister. Firstly, under which ministry does this corporation fall? Now, what supervisory role the minister play? So that we are talking about delineation of power here, so that the minister does not become overbearing and thereby stifling the function of the commission, so that the minister does not pack his family members to say, please, I am the supervising minister of your commission or your corporation. 3 of my younger brothers just graduated. Please find a place and fix them for me, whether or not they are qualified. So that the minister does not wake up one morning because he has a private or personal disagreement with the chief executive. He just say, you are hereby fired. So, functions of the supervising minister. He not do. What instruction can he give the executive officer, chief executive officer? What instruction can he not give? The chief executive officer is not subservient. So that should be carefully spelled out. Then we look at financial provisions, very important, relating to the statutory corporation, such as annual financial report to the legislature, as well as transitional regimes. 1, what are the sources of finance for the corporation? How are they getting their money? Can anybody wake up and donate money to them so that in 3, 4, 5 months' time, the person can now come up with a contract, seeing that, okay, we have supported you people, so you people, you owe me a favor, just find a way of giving me one contract to recoup my money. Can that be done? Is it acceptable? How do they get their money from governments? How do they get their money from international donor agencies? It will be spelled out. Are private individuals supposed to donate to them? It will be spelled out. Now, when the money comes in, how do they allocate the money? For what purpose is that money to be used? How do they retire monies? How do they account for expenditures made? Who signs before a withdrawal is made? Must the director of finance sign? Is it only one signatory? Or must every check be countersigned by the executive or chief executive officer? What is the mandate in the bank? You must put all this. Then, what about reports to the legislature? At what point should the report be sent in? Is it every quarter? Is it once in 6 months? Is it once in a year? If it is once in a year, when must the reports for that financial year be sent in? Then we talk about transitional regimes. Savings and transitions actually come under the final provisions. But here you are talking about the properties of the corporation. You are talking about employment, assuming the name of the corporation is changing, or assuming the corporation is being acquired by another organization, assuming the corporation is being merged. The people that were before, that were working under the corporation when it was known as ABC, now that we know it as BYZ, what happens to their employment? So you have to put it. What happens to their salary? What happens to existing contracts by the old statutory body? So carefully you draft out this, and the rule in drafting is that each subject matter takes a session. So you do not talk about transitional regime or submission of annual reports and delineation of power in one session. No, these are two subject matters. You don't combine the two. You don't talk about establishment of the statutory body and mode of employment under one session. No. So the establishment session will be separate. Then when you want to talk about employment, it is a separate session altogether. Any questions so far? Any question? Has anybody opened to the table of contents as I requested earlier of the acts we are using? Nigerian Communications Act. Okay, I am there. If you check section 3, the table of contents, section 3 says establishment of the commission. You deal with it under section 3. It can have subsection 1, subsection 2, subsection 3. You establish the commission. Section 4, functions of the commission. So you see that you did not join section 3 and section 4, the establishment and the function, under one session. If you go to section 5, you will see members of that's part 2, members of the commission. Section 5, establishment of governing board. You deal with it. Section 6, commissioners' remuneration, allowance, etc. That is entitlements, privileges, rights. You deal with it separately. 7, qualification of the commission's board. Who is qualified to be here? You deal with it. 8, appointment and tenure of commissioners. 9, resignation of commissioners. 10, removal of commissioners. Where a commissioner has defaulted, how do you remove the commissioner? 11, vacancy on the board. Where there is a vacancy on the board, how do you fill that vacancy? So, principal provision is the meat of the bill. Principal provision is the main substance, is the main thrust of the bill. What you do in preliminary, in a miscellaneous provision, is to put in place mechanisms that will ensure the realization of the principal provision. You also remove anything that will be a clog, that will become a hindrance to the realization of the principal provision. But the main thrust of your bill is the principal provision. Any question, please? So far, any question? Okay, can I ask my own question?
Go ahead. We're listening. Go ahead.
Okay, someone should tell me the three, my question, understand it. Someone should tell me the three subdivisions of the principal provision. Someone should tell me the three subdivisions of principal provision. Just volunteer, I volunteer. Somebody should tell me the three subdivisions of principal provision. I'm going to Mr. Yes. Okay. Now, I have successfully confused you. That is what I wanted to achieve. That is what I wanted to achieve. Please, principal provisions are subdivided into two, not three. Substantive provision and administrative provision. And that is the only part of the bill that has subdivision. The preliminary provision does not have subdivision. The principal provision. Hello? Okay. Okay. So I deliberately, that's why when I asked the question, I said, listen to my question again. That's why I said, listen to, that's why I focus preliminary provisions, principal provision, miscellaneous, and final. Then principal provisions are subdivided into two: substantive provision and administrative provision. So they are not three. Okay. So another question: what does substantive provision do? Substantive provision of, or rather, what clauses are found under the substantive provision of a principal provision? Because when you know these things, once you see a bill, you will know whether it is rightly drafted or wrongly drafted. Some people can carry a substantive provision and put it under miscellaneous provision. Once you see it where it is, this should not be here. This is wrong. The provision is correct, but the placement is wrong. Please note, substantive provisions introduces rights, powers, privileges, immunities. So once you see, when we were talking about the act now, and we mentioned, okay, tomorrow we'll do this assignment, and I mentioned under section 6, commissioners' remunerations, allowances, etc. These are rights. These are privileges. So that particular section is a substantive provision. You see how you get it. And if it is talking about delineation, if it is talking about finance management, administration, they are administrative provisions. How you should administer the establishment, the day-to-day running of the establishment. Who has what role to play? Who has what function to play? Who has what powers? Okay, the minister shall do this. The commissioner shall do this. The executive secretary shall have the power to do this. These are administrative provisions. Any question, please? We have less than 1 minute to go. Any question? Okay, in the absence of any question, remember that we have an assignment. Look at the widowhood leave bill, redraft it by incorporating the preliminary provision clauses that were omitted by the drafter. We specifically that last. If you look at the bill, there are some clauses that are not there that the drafter omitted. As a legislative drafting practitioner now, identify and fill them in and submit. Some of you submitted your assignments to me. Please kindly forward them to Prof, not me. Thank you very much. In the absence of any other question,